Thank you. Please be seated. Morning, Council. We're here for oral argument in case number 1, CACV 19-0310, Helen Schirmer, plaintiff appellant versus Avalon Care Center, Scottsdale LLC et al., defendants appellees. Council, just remind you that these proceedings are being video and audio recorded, so please identify yourselves and who you represent as you begin your arguments. Each side will have 20 minutes. Counsel for appellant, if you'd like to reserve time for rebuttal, please watch the clock and reserve as much time as you need for rebuttal. We won't remind you. Also, please keep in mind we've read the briefs, obviously, and we've conferenced the case this morning. So with that, Mr. Victor, you may proceed.
Good morning, Your Honors. My name is Jeffrey Victor. I represent the appellant, Helen Schirmer. May it please the court, I'd like to reserve about 4 to 5 minutes for rebuttal, if that's good. Your Honor, this particular case focuses on the accrual statute under ARS 12-542. But more importantly, we need to look at the particular conduct of each defendant and when that conduct was discovered. And the appellant's position is that the defendants and their conduct in this particular case were discovered during the discovery period of January 16th, or 2016, to the deadline date for discovery in federal court, which was March of 2016.
Counsel, could you bring that mic down just
yes.
a bit? Right.
I'm sorry.
We want to make sure you're heard.
Is that better?
Yes.
Thank you. So for purposes of the accrual date, we need to look at the specific actions of each defendant, and as the case law states, the who and what, and whether or not the plaintiff knew or should have reasonably known of the who or what conduct and at what point in time. The CDT case talks about the cause of action accrues when the plaintiff knows or with reasonable diligence should have known of the facts underlying the cause. And of course, the case law for the accrual dates always talk about reasonable diligence, but they also use the word when the plaintiff knew or should have reasonably known. So reasonably known, Your Honors, obviously is a question of fact for the jury. And in most of the cases that I've come across that talk about the accrual date focus on the fact that generally that is a question of fact for the jury. We have another little twist in this particular case, and which really has not been addressed by the appellee, and it's the concealment issue. The records from Avalon Healthcare, the admission agreement talks about the parties, and the parties being Avalon Care Center, Shadow Mountain, as the care center, as the provider of care. And that's found in the admission agreement. More importantly, it also talks about the nursing admission assessment, the initial pain assessment, the transfer discharge summary, post-discharge plan of care, all states Avalon Healthcare Incorporated.
Counsel, so when appellees denied, when the defendants denied in their answer that entity had provided care to the deceased, why didn't that put your client on notice of a reasonable duty to investigate at that point?
Well, I think perhaps under normal circumstances it may have, but when they do a joint report under Federal Rules of Civil Procedure, Rule 26F, they avow that
But just speaking of the answer, though, just the answer itself, could you not reasonably conclude from reading the answer that they're denying that they provided care?
Not necessarily when I have the records that held themselves out as Avalon Healthcare Incorporated. It certainly is a question of fact, if nothing else at that particular time, whether or not it should have reasonably been discovered at that point. And then we get into...
But let me pursue
Sure.
this just a little bit. So
Sure.
let's say that I disagree and that would have put a reasonable person on notice as of the date of the answer. So what is your legal conclusion to be drawn from that?
What?
Would it be 2 years from the date of the filing of the answer in which you would have to bring a claim against the correct entity? Or would it be some other time frame?
Well, it's my position that the accrual date first starts in January of 2016, because that's the first time that they identify that the defendant in this case is the actual provider of care. I don't know why they sat on that, for lack of a better word, for such a period of time. I don't know why they avowed to the court, the federal court, in the joint report, the language that they put in there. And the language that they put in there is the parties do not contemplate adding any additional parties or amending any pleadings at that time. Under the Mejia case versus Big Lots, they had a duty to speak up. They clearly had a duty to speak up under the Mejia case as to who third parties would be that would be responsible. Okay, they did not do that.
Did you do the discovery that would have led to that?
I'm sorry?
Did you do the discovery early on that would have led to the answers being given?
No.
Because then you've got the right to go back against them, and you
Right,
get to
well-
put the burden on them.
Yes, Your Honor, but the joint report was in September of 2015, and in the joint report there was set forth a discovery schedule, which would be, I think, March of 2016 was the deadline. So everything was proceeding as the parties agreed. I just don't know why you would, as a defendant, if you have an affirmative duty to disclose the name and of the entity who you say is the actual provider, I don't know why the defendants would sit on that September, October, November, December into January,
Well,
other than they're running the clock.
Can we flip that around? Why didn't you do discovery in regard to those very issues? Specifically, who are the responsible parties acting on behalf of? Or who are the responsible parties that harmed our client in this fashion?
Well, that's what the purpose of in part was the deposition.
And so you did that.
I'm sorry?
So you did that.
Well, I started the depositions pursuant to the discovery schedule in January, February, and in March, and I concluded within the agreed-upon time limits for the depositions for the discovery.
So did they lie to you in their responses in the deposition in regard to who the responsible entities were?
Well, they never came forward in the depositions to disclose that the actual provider is another entity. They did, for the first time, in all candor, they did say in January of 2016, that's when they first identified the defendant in this case. So it's my position at the earliest is when they first identify the defendant in this case, that's when the clock starts to run, or the accrual date. But in any event, then we have the issue with the fall incident report. Now, the fall incident report is very crucial in this case because the fall incident report memorializes the who and what and how the fall happened, what happened. As the director of nursing says, we do a root cause analysis. Those are her words, those are not my words. We do a root cause analysis to figure out how this happened, and it's not in the patient's records. It is not in the records that's given to the plaintiff or plaintiff's family or plaintiff's counsel. In fact, it's never given. Okay, so how are you going to pick up a patient chart and find out the investigation and the root cause analysis as to who was responsible, how the fall happened, under what circumstances the fall happened, when you have a fall incident report and their policy is don't put it in the patient's chart. That's concealment. Send it to the administrator, two administrators in this case, but don't put it in the patient's chart. Well, that's a policy of active concealment. And the only reason that came out was through the depositions. Again, starting in January of 2016.
So what's the significance of the fall incident reports? Because it's my understanding that you've never received those reports.
That's correct, but the depositions for the first time tell us, in part, who was watching over Mr. Schirmer on August 1st, that she, licensed practitioner, OPN McSwain says, I was the one that was watching him. He was my patient. I went to lunch. I left him in a chair. I didn't bother to check whether or not there was a chair alarm in the chair and whether it was activated. You don't know those from looking at the records.
So are you saying even after, at what point, counsel, could you have ascertained the names of the nurses that you sued in this complaint?
Well, it's not just the names. It's the who and what and how they fit into this and what the response.
But when's your conclusion? What is that magic?
When we start discovery, Your Honor, in January of 16.
So you had the names of the nurses in January of 16?
In January of 16, I had the names. I started doing the depositions, and I found out the what. I found out about the poor staffing.
But those names weren't added to the federal litigation, correct?
I'm
Or
sorry.
They were those?
No,
names?
no. You're correct. Those names were not in the federal case. You're correct. But the accrual date starts in January of 16. I have 2 years to bring a case against the particular people now that I have the who and the what, which is what the case law states. You cannot conceal reports. Okay, root cause analysis, fall incident reports. You
Are
cannot.
you suggesting that they concealed the fall incident reports?
They developed the policy. It's in the depositions. They don't put it in the patient's records. Send it to the administrators. Okay, that's a policy. But you don't even have to come up with that they intentionally deceived the patient or the patient's family or attorney. You don't need that for concealment. If you find concealment, then you find the statute of limitations is told. Okay, and certainly one can argue that when you come up with a policy that there's a full incident report, that a root cause analysis that spells everything out, but don't put it in the reports, don't give it to the patients or the patient's representative. Certainly one could argue that that is intent to deceive, but you don't even need that. Any form of concealment will told the statute of limitations.
Counsel,
Yes, I'm sorry.
Just a point of clarification.
Sure.
When you say you became aware of, I want to make sure I understood you correctly, there's a couple of nurses that you deposed.
Actually, there's about 4 or 5.
Okay. Some that gave care to the deceased.
Yes.
And are you saying that you only learned of their names in January of 2016?
No, those names, Your Honor, were disclosed when we were doing the initial disclosures, but that's fall of 2015. Okay, that's when the initial disclosure took place. But the initial disclosure doesn't put me on notice as to the who and what. And the what part is there's no way you can glean from the records what happened. Okay, the what part would have been the fall incident report, which was intentionally concealed, not even mentioned until I asked questions in the deposition. The what part, you're not going to find out reasonably, discover the what part until you take depositions.
Okay, so you got the news as to who the names of the players. You got it in January of 2016.
The names, 16.
I wasn't sure if it was 15 or 16.
Yeah.
And how soon after that did you set and take their deposition?
Well, actually, Your Honor, I think the witnesses, the supposed witnesses from the facility were disclosed in fall of 2015.
Okay, so we're going clear back to fall of 2015 now. You know who those players are at that point.
Yeah, and then we scheduled the depositions starting in January.
So 3 or 4 months later.
Yeah, with the holidays and everything, we started, and we had a deadline that was approved in March of 2016.
Thank you.
But if the names are disclosed in fall of 15, and the case is filed in July of 17, it's still within the 2 years. So I'm running short on time here, Judge, but there are many cases to look at that talk about constructive fraud. The Walk versus Ring case. There is, and they all talk about it's not enough to know about the particular who, you need to identify the what. And they all talk about usually and necessarily questions of fact for the jury. The defendant shouldn't be rewarded in this case. They hid and didn't even mention and didn't put in the disclosure in the records the fall incident report, which is the root cause analysis, their words. And now they're coming forward and they're hiding behind that, and they're saying that the time has run. They should not be rewarded. Thank you, Your Honor.
Thank you, counsel.
Good morning. May it please the court, I'm Blake Miller. With me is Craig Howe. We represent the defendants and the appellees in this case. This is an unusual case for a statute of limitation case. It's unusual because of the number of factors we have. In this case, before the expiration of the statute, the plaintiff knew of the death of Mr. Schirmer. Before they filed, they got the full medical records, including the nursing notes.
Did
So
the
they have-
records identify the identities of both?
Yes. It has the entire nursing record, and each nurse puts down what they have done that day. It has, with those medical records, they gave them to an expert. So pre-litigation, they hired an expert, Wendy Thomason. She opined that this particular nursing home that they identified and its staff had committed negligence. And then they sued on that after making demand and before the lawsuit, giving that expert report over to the nursing home. The important thing is all that information is available pre-suit. So we've got a case here in a statute of limitation case where you've actually sued on that claim. In addition, counsel asked, why did we sit on it? The answer is easy. They made an intentional choice to sue this particular defendant in the federal action, Avalon Healthcare Inc. It was a great-great-grandparent of the nursing home. But they decided, and it's been acknowledged by counsel, that was, they believe, the deep pockets.
Where did they get that name?
I don't know. It's one of the, I don't know where it got.
Was it on the paperwork?
Could you take a guess, counsel? Where do you think they got that name?
I believe they probably got it off the website.
And so on the website for the nursing home, it has this name.
No, there's a website dealing with the Avalon group of companies, and if you look at the bottom of, I believe it's on the bottom, it says Avalon Healthcare Inc. is one of the entities. Avalon Healthcare Inc. is the holding company for a series of companies that owns nursing homes in states. Arizona has its own subsidiaries, and this nursing home is owned by a specific LLC. It's all a 5-minute check online would have shown this, but they didn't want, that entity had been sold. The nursing home had been sold by the time they sued. They were trying to get what they called corporate. One just has to look at, it's in the record number 40 or number 34. In the federal action, we moved for motion for summary judgment, saying, I know you want to get corporate, but this entity is a holding company. We had nothing to do with the care to Mr. Schirmer. In response, and that's the record I just gave you, the plaintiff didn't say, what? This isn't the name of the nursing home? We want to sue the nursing home. They say, oh, no. We want to sue Avalon Healthcare Inc. under a unity of control theory. We believe that entity controlled the nursing home through budgetary processes and providing forms, and should be liable for what the nursing home did or didn't do with regard to Mr. Schirmer. In addition, we want to argue that they are the alter ego of the nursing home.
All that sounds possible, counsel.
I'm sorry?
I said all that sounds possible.
It is a strategy often employed by plaintiffs in nursing home litigation.
I was going to suggest that next.
Right.
Often.
And so we weren't surprised by that. That is something that we do. And we defended it on wrong entity. This entity didn't have any budgetary control. This entity, in fact, had no employees. It's a holding company. And the alter ego didn't work. My point was, now, after that case got dismissed by the federal court on several grounds, including no alter ego, no unity of control, at least no disputed issues of fact on that, the plaintiff did an about change. Said, okay, I'm going to apply a dual strategy. I'm going to appeal that, and I'm still going to argue that Avalon Healthcare Inc. had that unity of control before the Ninth Circuit. And I'm going to start a new action. This time, I'm going to sue the nursing home. And I'm going to sue the individual staff members. And I'm going to pick 2 other companies. I don't know why they picked those 2, but they sued 3 companies, the nursing home and 2 others.
Out of a plethora of other businesses, you're saying?
Yes.
So rather than everybody, they just picked a couple?
They picked 3.
Okay.
And they picked this time the right legal entity. They picked the name. By the way, the name of the nursing home, it goes under a trade name. And that's what's commonly known. If you look at the admission agreement, that's what it's done. They could just suit us on the trade name, and we'd have been there anyway. My point is, it was an intentional decision to sue Avalon Healthcare, Inc. Now to claim there's concealment, we hit it. It changes the whole nature of what that federal district court action did. They didn't want to sue the nursing home. They wanted to sue the great-great-grandparent, thinking that was the deep pockets. So now to
Was
come
your
in...
client under a disclosure obligation in federal court to disclose interested parties or parties that would have information relevant to the dispute? How would, in your disclosure?
We are under Rule 26, and I'm trying to visualize it in my head. We are to identify individuals with discoverable knowledge. We did. And in the
You
joint management...
identified this entity,
The Avalon Care Center Scottsdale LLC.
that was identified in your Rule 26.
I don't know if the
Disclosure?
entity was, but all the individuals who worked for that had knowledge as to Mr. Schirmer's care were identified. And if I look at that report is number 40, I don't have it right now, it's 42, I believe, in the record. But you'll see that we're required to identify our parents. It's for conflict purposes. And there's nothing in that joint report that says we have to say, well, we believe someone else, you should be suing somebody else. We don't like your theory. We think you should be suing the nursing home or that. But we are required to identify in the disclosures the individuals with knowledge. And those are the people who provided care at the nursing home. We did it, from the administrators down to the nurses. Even though they weren't employees of Avalon Healthcare, Inc., they were employees that had discoverable information on the claim. And they were identified. There's nothing in that joint management report, and you can look at it, Your Honors, that obligated us to say, here's the legal name of the nursing home. But we did provide that anyway during the case in context of discovery. We gave it to them. It was never hidden. And there would be no reason for us to hide it. It's a 5-minute check with the Arizona Corporation Commission.
How was it identified in its disclosure?
I'm sorry?
How was it identified in its disclosure? As the parent company controlling blah, blah, blah? Or was it described in some other way? Or was it just a name?
Well,
Wasn't
it
as part of an interrogatory?
in an interrogatory, it was disclosed. Because we defined the facility, and we said the facility is this facility owned by here. Legal owner is X. And when we defined who the facility was. In the federal management case report, they ask you to disclose of this particular defendant who its parents are for conflict purposes. Avalon Healthcare, Inc. has no parents. It is the ultimate holding company. But there was, from day one, they had all the records, the medical records, to show the trade name, for example, which is how this nursing home holds itself out to the public. How it notifies people, and it could have easily been sued under that trade name as well. Or when we brought the motion for summary judgment saying, you're suing the great-great-grandparent, we have no unity of control, we have no employees, we didn't provide care to this particular individual, no one at Avalon Healthcare, they didn't have employees to even act, could be held liable. If they really wanted to sue the nursing home and really thought that that's what they wanted to do, you'd have heard of, oh my goodness, we got the wrong entity, let's amend. They didn't. They proceeded forward. They didn't even pause. And if you look at their reply memorandum, it's no, we want Avalon Healthcare, Inc. under unity of control, under an alter ego theory. That was their intentional decision. So to argue that we're concealing something that they intentionally decided otherwise doesn't fly. Even if there had been a lack of disclosure on the legal name, even if they really wanted to sue the nursing home and not the great-grandparent, even if they weren't going for a unity of control or an alter ego case, the law is clear that the plaintiffs have the obligation to ferret out the legal name if they don't want to sue under the trade name. The Lawhorn case cited in the party's memorandum cites a number of cases when it comes to the conclusion of who and what and who. And it cites the Lizzo case. And Lizzo case states that, and I read from it, these cases stand for the proposition that when an injured party has knowledge as to who as well as what inflicted his harm, it's not unreasonable to impose on him, the plaintiff, the obligation to investigate the, quote, legal identity of the tortfeasor. or whether any entity is vicariously liable for the tortfeasor's conduct. Once the plaintiff has knowledge as to the identity of the tortfeasor, here in the nursing home, he has sufficient information to commence an investigation of the tortfeasor's employment status, corporate status, and other legally recognized affiliations. Indeed, that's the type of inquiry that most tort plaintiffs employ. None of this is hard. It's literally a 5-minute check had you wanted to do it. We believe that was not what they were trying to do based on everything that's done in the federal court, even through the appeal. It was always, we want the parent, we want the ultimate corporate. And that's how it was defined. It was corporate. So they didn't want to sue the nursing home, they wanted to sue corporate. As far as the incident reports are a very common document used in the nursing home industry and in hospitals. They are internal quality assurance documents that summarize the nursing records and sometimes come to what happened here, but they are that part of the quality assurance part of those reports are not discoverable. The factual summaries of the nursing reports are, and we often have fights in these cases, how much of those reports come in, what doesn't. To the extent they just summarize the nursing reports, those parts get produced. But the point is they just summarize the nursing reports. The root information is in the chart. These incident reports are not part of a patient's chart. They are given to the firm administrator or the nursing home administrator for purposes of quality assurance going forward. In this case, because the nursing home had been sold, we couldn't locate those documents when asked. And they were asked late. It was an untimely request for these documents, but we went through, and remember, Avalon Healthcare Inc. doesn't have those records. But we went back to the owner of the new nursing home to say, can we find them? And we couldn't, so they couldn't be located. To this day, I don't know where those are or what happened to them. Again, but they're not part of the chart. They're just internal documents. If they were that critical, the plaintiff couldn't bring an action without them, then it's a little tough to bring the action now because those documents don't exist on this case. But they clearly could have commenced an action before because they did twice. As far as the identity of the people, the identity of selecting these deponents was known in the medical records given in late 2014. Those records had all the nurses and all the parties to this event. Based on those records, plaintiff's counsel informed us who they wanted to depose and took those depositions. It was not a situation where we had to tell them who was involved and why. All that information's in the chart on an hourly basis on what occurred. Plaintiff made the selection and knew who he wanted to depose because that information was available before she sued the first time. The bottom line is the plaintiff believed the first time, as January 19, 2015, they sent a letter saying, we've done our investigation, we have a claim against this nursing home, we want you to pay it. It was followed up a few weeks later by, here's a copy of our affidavit of the expert saying that your nursing home staff committed negligence. As of that time, they had the standard requirements enough to file the case, and they in fact did.
As to the individuals that provided care in the nursing home, but not necessarily the corporate, correct? Are you saying as to corporate also?
Well, the first lawsuit was to corporate. And they're basically saying we're going to hold corporate liable for this nursing home. And they sued corporate. They did not sue the nursing home the first time. And that went all the way to the Ninth Circuit with the idea of unity of control and alter ego.
And did that complaint have the negligent administration claim in it? Was there a claim for negligent administration, so to speak, the administration mishandled policies and procedures, hiring practices were negligent, et cetera?
That in operation management and, hang on, I've got the complaint. And basically in managing and operating and overseeing the nursing home, they failed to meet federal standards. Those are the same federal standards they're seeking to hold the administrators liable for separately. But this is basically a malpractice, a medical malpractice case. And there's one injury, one harm, one death. You don't separate it by each of the staff members and sue individually and then have separate statutes of limitation for every nurse, for every CNA, for every RN, for the janitor, for the administrators. When you sue a nursing home, it's one claim. Now, you can say the nursing home can only act through its agents, and you can hold those responsible for their own individual torts, but it's one claim, one statute of limitation. You don't take one medical malpractice claim and divide it to 30 different statutes and 30 different claims. As far as the administration claim, Your Honors, the plaintiff is being a little inconsistent. They're saying there's no individual claim. If you look at the reply brief, they also say we are seeking that individual claim. So they're even inconsistent with that. But it is, I'm not certain what page it is. Let me see if I can find it. It's fine. But there's an inconsistency of their claim. But there's no new facts alleged in the second complaint. They're just saying individuals or administrators are liable. It's much like suing a hospital and a doctor and the nurses for a hospital malpractice. It's one injury, one claim, bring it now, bring it in one case. But there's not separate statute of limitations. Plus, the identity administrator, which is also a public record, this is all online, the nurses, all that was known in 2014 when the medical records were given.
So the knowledge of the identity of the nursing staff wasn't going to provide them with, I want to get this right, it wasn't going to enhance their claim under the complaint?
No. Well, a nursing home can only act through its employees, and to the extent a nurse screwed up, you're going to hold the nursing home liable. And so it's important to know who the nurse was and what they did, but that was all given to Wendy Tomlinson, the expert, who concluded that the staff had committed negligence back in early 2015. Well, I don't know when she rendered her opinion. It was given to us in early 2015. She probably did it earlier than that.
Okay, thank you.
But what the nursing reports will go through, show the nurse, and a summary they dictate or write in the nursing chart that day of what they did. So you can see almost on an hourly basis the date, the time, the nurse, the provider, and it just goes page by page by page. There are voluminous pages in these nursing records. By the way, the only forms that showed Avalon Healthcare Inc. were 4 forms out of those hundreds and hundreds or thousands of pages.
There's a big difference between knowing who the ground level employees, if you would, who they are for purposes of deposing and questioning and checking credentials and things like that, and naming them as liable parties in the lawsuit, correct?
Correct, but the information on what the nurses did or what they failed to do was available in the medical records, and Wendy Tomlinson, their expert, before the first case, had decided she'd reviewed those records and made the conclusion as an expert that the nursing staff had been negligent. She already made that determination before the first case was filed.
And saying that she'd made, I'm sorry, go ahead.
I was going to switch topics.
I'm not surprised.
There's a second expert, though. Isn't there expert Yules that provides an affidavit saying from depositions, for the first time we learned that there's nursing home administration negligence. Isn't that different, though? Isn't the what and who maybe discoverable later in time on this issue as to corporate than it was as to those that were on the ground level providing care for the decedent?
Lance Hughes actually filed 2 affidavits, and the second one just said, I learned more in the depositions. But he was able to identify the administrators. It's all online. And the argument is, as is often always made in nursing home cases, that there's a failure to fund profits over people.
Even on that issue, the timing goes back to 2014 is when the statute of limitations runs. Is that your position?
I believe they had the information by late 2014, but I can tell you by January 19, 2015, when they send us a demand letter saying, our experts review these records, you're liable. That's on everything. That's the whole claim. And the standard is, I don't think there's a dispute on the law, it's the minimum requirement to put them at notice to investigate.
But isn't that reasonable notice? And that's the issue. The argument is, isn't that an issue, a question of fact for the jury? What's reasonable? When were they on notice?
If there are disputed issues of fact that the jury could reasonably render a verdict as to lack of notice or lack of reasonableness, then that's a question of fact. But here there is no disputed issues of fact because the facts are clear that by January 19, 2015, they had every piece of information they needed to at least do the investigation, the minimum requirement. Every case you learn stuff. I learn everything through trial. And sometimes after trial, I learn something new. That doesn't mean the statute of limitations waits till after the judgment. It's the minimum requirement to commence that investigation. And that's why you often do John Does. If they, for some reason, didn't want to check up CMAs or the requirements or the online requirement, or online listing of administrators, they could have said John Doe administrator and filled in the blank later. But they didn't because they were going after corporate. Now they've changed. There's no other questions. My time's up.
Thank you, counsel.
Thank you.
If I may, Judge Jones, you asked a specific question as to where the naming of the Avalon Healthcare Incorporated came up. It was in the patient's records. It was in the nursing admission assessment. And this is all part of the record. It was in the initial pain assessment, Avalon Healthcare Incorporated, and it was in transfer discharge summary, Avalon Healthcare Incorporated.
So when you had those documents, you had that information?
I had the documents, and the documents led me to believe that this was the defendant that was providing the nursing admission assessment, that Avalon Healthcare Incorporated, not this defendant in this case, was doing the initial pain assessment, and that Avalon Healthcare Incorporated, not this defendant, was doing the transfer and discharge summary. And and the question is whether I reasonably relied on that. Again, that's a question of fact.
Did you also go up on the internet and check their internet presentation?
To be frank, I don't know if my paralegal did or not, to be frank with you. But this is what we reasonably relied on, and it's a question of fact for the jury.
Counsel, I'm troubled by the fact that the way Mr. Miller is presenting this is, and it makes some sense to me, maybe more than from reading the briefs, but that you conscientiously, you sued the client in federal court. You wanted to sue. And that is the client that you wanted to, that was your theory. You wanted to get the corporate head, so to speak.
Your Honor, in all due candor, yes, but I still had the option when I found out for the first time who the actual provider was of care. And
but can you bury your head in the sand, so to speak? I mean, on retirement case says that you cannot just sit back and say, I don't have a duty to investigate. I can just wait until this information comes to me.
Well, I don't think I buried my head in the sand. The first time that they disclosed it, despite the 26F report, where they said that there would be no amendments, was in January of 16. But if I may.
So you're saying, why, when that happened, help me understand, when you found out the name, why not seek to amend the complaint in federal court at that point? Because
at that point, the facility had been sold. The parent corporation was the one that was named in the lawsuit. And from my review of everything, they exercised a degree of control over the care that Mr. Schirmer got by virtue of the records. Now, it isn't until January, February, and March of 16 that I find out from the depositions, and there's no way you can find this out in the records, so I beg to differ. And the DON Holmes said that this was a struggling facility, that this had a poor staffing ratio, that there were poor quality care metrics, that there were medication errors, infection control issues, quality complaint issues, that there was no assistant director of nursing, which contributed to the facility struggles, that there was no policy for care plans for high risk for fall patients.
What's the date of that document?
I'm sorry?
The date of your...
That all came out of the DON Holmes' deposition testimony in January of 16.
Okay, thank you.
There's no way you could glean that from the records. There's no way you could find that out. There's no dedicated area for dementia patients who she said required higher supervision. Again, you can't glean that from the records. There were no alarm policies in place that patients in a chair that are high risk for falls should have a sensor pad in the chair, or they should have a tab alarm. No such policies in place. Again, you can't glean that from the record. That they were short on nursing managers. There were 2 actual nursing managers that quit. And she testified that the nursing managers were very important to patient care. That the fact that the 2 nursing managers was missing directly reflects on the patient care. And then we get to the administrators, okay? The administrators were making decisions about expenditures. They were disapproving requests from regarding increased staffing. They were disapproving requests regarding a raise in pay so they could get quality applicants. They were disapproving requests for chair alarms or bed alarms. They were disapproving requests to replace the nursing managers. There's no way you can get that from looking at the records. The who and what you find out regarding the administrators, you find that out for the first time when you do the discovery. And nobody is arguing that the discovery wasn't done in a timely manner. It was stipulated that the depositions would be completed by March of 2016. Even Lance Yules, the administrator expert, says, these issues, no way you could find this out from the review of the records. I found out these issues about the administrators for the first time from reviewing the deposition transcripts. And Wendy Thomason, her affidavit was a preliminary affidavit, subject to modification as discovery comes in. So you have the opportunity here to look at different accrual dates for different professionals, for the administrators and what they failed to do and their decisions. Well, that doesn't come to light until January, February, and March, along with the other individuals and what they did or didn't do. One last thing, OPM McSwain said that the notes were sparse regarding the fall, and that if you really wanted to find out how the fall occurred, you had to look at the fall incident report. Thank you.
Counsel, thank you both this morning for your arguments. We will take this matter under advisement and issue a decision in due course. Thank you. Court is adjourned.